Hi guys. So in this video, we are going to look at the constitutional law, which shall be relevant for the purposes of CLAT 2020 and somewhat beyond. So constitutional law is the supreme law of the country which governs every aspect of the governance. Now, as the name states, this flows from one singular document called the Constitution and other laws that are, say, related. So, today we are going to look at the Constitution of India. The Constitution of India was made by the Constituent Assembly between 1946 and 49 and was brought into operation from 26th of January 1950. Now these are the dates you already know, so let's come straight to the point. So the Constitution as a document is divided into multiple parts and schedules. The parts are the collections of operative provisions which determine or tell what is to be done in what manner, and the schedules are lists of entries which then help or say tell the government what to do in which entry should be treated in which manner. So we shall come to all of that later. Let's start with the preamble. Preamble to the Constitution of India. So preamble is an what can you say? It is an introductory sentence. The preamble is one single sentence which introduces the Constitution of India. So you must have read the preamble in your school several times, and I shall read this out for you, and then we shall discuss certain terms or concepts which are used in the preamble. So it starts with, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of this nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution." Now, this text has been repeated before us several times, but today we shall look at the concepts. So, the concepts mentioned in this are those. One more important point is that this preamble was inspired from the preamble of the United States. So that begins, "We the people of the United States of America do this." So that is the, if it can be a question in the general knowledge section, where it inspired from. So the concepts that I found relevant in the preamble are these. Five terms which are written as adjectives to how the Republic of India is going to be, Union of India is going to be, and four aspirational values that it ascribes to itself as a nation. So we are going to look at them one by one. First is sovereign. Sovereignty can be understood as an say opposite of colonized or not independent. A sovereign state is one which is independent in taking its own decisions regarding matters including but not limited to foreign policy, defense, and internal administration. Before this constitution was brought into operation and the Britishers had left, that is the period between 47 and 50, India was a dominion of India. And after this was passed, India became a sovereign nation. So sovereignty as a concept is this. Socialist. Something worth noticing here is that these two words, socialist and secular, were not there in the original draft of the Constitution. These were added in the preamble via the 42nd Amendment of 1976. Now, socialism as we understand as a goal is a state where The wealth belongs to the people, to the state in a manner which shall ensure the greater good of everyone. Now, secular. Secular is understood and misunderstood by all of us in multiple ways, but in the in the context where it is used, secular essentially meant in the context of Europe, separation of the church and the state, which means the state shall not interfere in the matters of religion, and the religion shall not interfere in the matters of the statecraft. We'll come to this later, but for now, that's it. Democracy comes from the Greek words demos plus kratos, where demos means people and kratos means rule or governance. So democracy is just rule of the people. Republic is a kind of state where the head of the state is an elected representative. The opposite of republic could be understood to be a monarchy, where the head of the state would be hereditary, or some system like a military junta where the military generals are the head of the state. So a republic is where the head of the state is an elected representative, directly or indirectly. Election is what matters. Now, these terms are done. Now, in the preamble, we have four aspirational terms, four aspirations for a new nation as was thought about by the constitution makers. All of these are supplemented by terms. So justice, it says justice, social, economic and political. So how would you understand justice? Justice, equality, all of them actually are not terms which can be defined in isolation. These are things which need to be understood with relation to their opposites. So justice, best defined, would be the absence of injustice. It is a heavily debated subject, but the constitution, the preamble, qualifies justice. It says social, economic and political. Social justice would be where the citizens of the country, the society, shall be a just society. The outcomes shall be proportionate to the efforts put in, or say equality. Justice should be where the social, economic and political conditions of the people shall be not unjustly exploitative or how do you explain? Okay, justice would be where social, economic and political life of the citizens shall not be unfairly prejudiced by the state or any other agency. Liberty is qualified by saying liberty of thought, expression, belief, faith and worship. So liberty is synonymous to freedom, but freedom of what? Of thought, expression, belief, faith and worship. So every citizen of the nation shall be free to have any thought, express that thought, have a belief in a system, a faith is in the matter of religions, and to worship or practice or profess his or her religion. Equality of status and opportunity is pretty self-explanatory. Equality shall not just be formal equality but substantive equality as well. So equality of opportunity refers to substantive equality, where the state shall take extra efforts to ensure that there is equality rather than just avoiding unequal treatment. And fraternity assuring the dignity of the individual and the unity and the integrity of the nation. So the commonly used phrase is all Indians are our brothers and sisters, but in the legal context, how we understand it is that every individual shall be treated with dignity. No individual shall be discriminated in a manner which is prejudicial to his or her condition in the society as an independent member, and unity and integrity of the nation is taken. Now, this is preamble. So the next topic is the union and its territory. This is part 1 of the constitution, which is article 1 to article 4. what is relevant for us is this. Article 1. It says India, that is Bharat, shall be a union of states. So, for the purpose of the constitution and governance, the territory of India is defined as a union of states. Clause 2 says the states and the territories thereof shall be specified in the first schedule. So I was talking about the schedules of the constitution. These are there are 8 schedules in the constitution initially. Now there are 12. So the first schedule of the constitution specifies the territory of India. Clause 3. The territory of India shall comprise A. The territories of the states, B. The union territories specified in the first schedule, and C. Any other territories as may be acquired. So this is what the territory of India shall be. Article 2 says Parliament may by law admit into the union or establish new states on such terms and conditions as it thinks fit. So the power to admit new territories in the territory of India is vested into the Parliament only. Article 3 is what is important for us. So India is understood to be a federal nation, but some jurists describe it as a quasi-federal nation. So for the federal mechanism of the nation, India is divided into multiple states, and it says that the Parliament may by law form a new state by separation of territory from any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, or alter the name of a state. So all these powers have been vested in the Parliament by Article 3. But it says provided, there is a proviso which says provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries or names of the states, the bill has been referred by the President to the legislature of such state. Now what does this mean? This means that the Parliament has been given the powers to alter the name, boundaries, size of the states, create new states, merge two states to form a new state, and do as it may. But the proviso to this is that such a bill should be brought in by the after the President says so, and if it alters the name of the state, boundaries of a state, or increases or diminishes its area, such a bill shall be first recommended by the legislature of the state to the President, and the President shall then send it to the Parliament. However, this is not mandatory. In recent times, we had the states of Jammu and Kashmir, whose boundaries were altered. It was actually removed from a state and made into a union territory. Some years ago, we had Telangana, which was separated from the state of Andhra Pradesh. Before that, we had Jharkhand, Chhattisgarh, and Uttarakhand, which were carved out of Bihar, Madhya Pradesh, and Uttar Pradesh, respectively. So, such things are in the power of the Parliament of India. So, this was about union and its territory. The next topic is citizenship. So, this is something which has been into much debate and discussion, especially in this year. This year we had the Citizenship Act, which was amended by the Citizenship Amendment Act, and widespread protest that we saw. Now, what happens is about citizenship. So, this is done. About citizenship, what is to be done is that we need to understand what the Constitution talks about citizenship. For citizenship, it says, Article 5, it says, at the commencement of this Constitution, every person who has his domicile in the territory of India, and A, who was born in the territory of India, or B, either of whose parents was born in the territory of India, or C, who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. Now, what this means? This means that at the commencement of the Constitution, which is 1950, any person who was born in the territory of India, either of whose parents was born, or has been living in this territory for at least a period of 5 years, immediately preceding the commencement, which is 1950, shall be a citizen of India. This is Article 5. Article 6, we all know the historical backdrop of citizenship because the debate was regarding the partition and the large scale migration, the largest human migration the human history had ever seen in the modern times. So Article 6 deals with that. It says, notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this constitution if he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted. Now, Clause A, 1935 Government of India Act would mean India would include today's Pakistan, Bangladesh and India, the whole territory. And so Article 5 had or, but this is qualified by an and. So all the essentials need to be fulfilled. A is a mandatory provision that he or either of his parents or any of his grandparents should be born in the territory of India as defined in the 1935 Act. And B says 1. In case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or in the case where such person has so migrated on or after 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government in Dominion of India or by an application made by him therefore to such officer in the form and manner prescribed by that government, provided that no person shall be so registered unless he has been residing for at least 6 months preceding the application. Now what this meant? This meant that to be a citizen of India, using this provision, you had to satisfy these essentials. First was that either you or either of your parents or any of your grandparents were born in the India before partition, and if you had migrated before 19th of July 48, you shall be living in the territory of India since the date of your migration, or if not so, if you had migrated after 19th of July, you have to be registered in a government office in front of an officer who is so empowered to register you as a citizen. Now again another article, again a notwithstanding clause. It says notwithstanding anything in articles 5 and 6. So the previous two articles, notwithstanding anything in them, a person who has after the first day of March 47 has migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India. So a person who migrates to territory of Pakistan shall be usually fulfilling all the criteria in either 5 or 6. But if you have migrated to Pakistan, you shall not be a citizen of India, provided that nothing shall apply to a person who, after having so migrated to territory now included in Pakistan, has again returned to the territory of India under a permit for resettlement or permanent return issued by the authorities before the 19th of July 48. So if you migrate to Pakistan and you wish to come back, if you had come back through this legal process, through either a permit or a resettlement or permanent return permit, you can again be a citizen of India. Article 8 is again a notwithstanding clause which applies to Article 5. What was Article 5? Article 5 was anyone who was born or parent were born or has been living for not less than 5 years in the territory of India when the constitution commenced shall be a citizen of India. Now notwithstanding this, any person who or same conditions who himself or either of his parents or any of grandparents were born in India as defined under the 1935 Act and has been residing in any country outside India shall be considered to be a citizen of India if he is registered by the consular or diplomatic representative of India in that country, and that should be on following an application which is made by him to such representative, whether before or after the commencement of this constitution in the manner provided in the law. Now what this means is a person who is eligible for the citizenship of India except for the fact that he is not living here shall also get a citizenship if he applies for citizenship of India in the consular office of India in that nation. So this was another method of gaining citizenship, which was to apply for citizenship in the embassies in that respective countries. But you should be fulfilling all other requirements, which is that of birth or your parents or grandparents being born. Now, Article 9 is what demits you of what cancels your citizenship. It says no person shall be a citizen of India by the virtue of Article 5 or deemed to be a citizen by virtue of Article 6 or 8 if he has voluntarily acquired the citizenship of any foreign state. So you can't be a citizen of India while you're a citizen of any other state as well. So if you demit the citizenship of, if you acquire the citizenship of any other country voluntarily, you automatically are considered to have left the citizenship of India. Now, Article 10. It says every person who is deemed to be a citizen of India under any of the foregoing provisions of this part shall continue to be citizen, and any law made by the Parliament shall continue to be a citizen. So the presumption is in favor of citizenship. A person is a citizen of India unless he demits it or leaves the citizenship of India. Article 11. This is also relevant in the discussion in light of the Amendment Act. It says nothing in the foregoing provisions of this part shall derogate from the power of the Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. So it says citizenship as a matter shall rest with the Parliament as an entry to legislate upon, and the Parliament shall have absolute rights to legislate. Now, to briefly summarize this part, citizenship of India can be acquired by these following ways. First is birth. So you, if you are born in the territory of India, you are a citizen of India. Descent, if either of your parents or grandparents have been born in the territory of India, you are a citizen of India. You can get registration. So you can get registered in the territory of India for citizenship of India, either when you register at the deemed office where you have, after you have migrated from the territory that's now in Pakistan, or you register at the consular access if you are entitled to a citizenship of India but you are a resident of some other country. You can register at the consular access in that country. And the next is naturalization. So this is not from the Constitution, this is from the Citizenship Act, which said if you have lived in the territory of India for a certain number of years, you are by virtue of naturalization a citizen of India. Now, to briefly touch upon the problems that were with the Act, that said a person shall be deemed to a citizen of India, shall acquire citizenship of India if he or she is from a minority religion in the countries of Afghanistan, Pakistan or Bangladesh, and has spent not less than 5 years in the territory of India preceding the date. So this was talked about a lot in the media, and because the Act specifically did not say minorities but it specified the religions, it said Hindus, Christians, Buddhists, Jains or Sikhs. So this was the reason of controversy, because it excluded Muslims from being included as citizens of India, and this was termed as a violation of the right to equality. That's basically what the relevant parts about citizenship are. In the next part, we shall be dealing with the fundamental rights, part 3 of the Constitution of India.